Liebe Kolleginnen und Kollegen, eine letzte Chance, sich noch was zu essen und zu trinken zu holen. Sie sind herzlich eingeladen, es zu den Tisch mitzunehmen und wir werden dann versuchen, um halb, weil wir auch streamen, um halb relativ pünktlich zu beginnen. This is your water?
Yes, sir. Thanks. Didn't know, I just took it yesterday, so I still have it.
It doesn't look that fresh. Yeah. Ja. Dankeschön. Ziehen wir es weiter. Gut, sehr geehrte Damen und Herren, liebe Studierende, liebe Kollegen, herzlich willkommen zum technisch gesehen zweiten Werkstattgespräch des Jahres 2025. Das erste musste leider entfallen wegen einer Verhinderung der Sprecherin, deswegen materiell das erste. I will now switch to English because our speaker today understands German passively, but she's even better in speaking Italian, English, and other languages. And today's speaker is Professor Filomena Chirico, who is head of unit at DG Connect and was involved not at that DG, but in the cabinet of the Internal Market Commissioner Breton in the drafting of the DMA, and is now active in the enforcement of the DMA, about which we will hear more today. And like I said, you have a long career in the Commission, in the cabinet of the Internal Market Commissioner. Before that, in the antitrust unit of DG Comp in telecoms specifically. But you also have had and still continue to pursue an academic career as an assistant at the University of Tilburg. That's why I have this sheet up here. You have an impressive amount of degrees from universities, from your alma mater, Luis in Rome, to Rotterdam, Hamburg, Berkeley, and your PhD at La Sapienza. But first and foremost, I'm very happy, and this is actually also the context where I was bold enough to approach you, that we're colleagues at the Collège d'Europe in Bruges, where you are also a visiting professor. We are very glad and honored that you're here with us today. Before I leave the floor to you for a presentation, which will then be followed by questions, answers, discussion that you may have. Just two remarks. One of them is housekeeping. I said before, and I invite you again to make use and enjoy our buffet today that is provided courtesy of our sponsor, law firm Zerha Hempel, represented by Hans Christopherich there at the back. We're very glad that you keep sponsoring our events. We also collaborate in other contexts, and Terra Hempel is not just a law firm that takes care of students now in the context of the European Law Workshop, but also as a potential employment, very comfortable and a suitable employment opportunity. So thank you, Hans, and thank you, Terra Hempel, for sponsoring our event. Second, before I thank my team, second housekeeping rule, so please grab some food. Secondly, be please aware that we do stream our event, so I do also welcome those who join us online. If you intervene, so if you speak, be aware that we do stream. Please, for that reason, use the microphone. If you speak up, if you formulate an intervention, we assume that you consent to being streamed. If not, you are not visible as the audience on the live stream, so there is no need to consent to the live streaming of that. But if you do intervene, please use the microphone so people online can hear you. If you are online, you have a question, you can type it in the chat, and we will read it out for the discussion afterwards. And lastly, and not least, I would like to thank my team who has made this event possible by organizing, preparing, being in touch with the speaker, the sponsor, all of you. And those are, I see Rose Franzen here, but also Petja Petrova, Patrick Marek, and Kerstin Schatz back there. Thank you very, very much for organizing the event and making this happen. So I would suggest an applause to the sponsors and the team, and then we'll get started with the presentation. Thank you. The floor is yours.
Thank you. Many thanks to Thomas, to the team for allowing this to happen also on my side. And I'm told that I should say when I land in Austria something like I can choose between Grüß Gott, Servus, or the latest in my list is Oida. I don't know what that means. I hope it's not a bad word. That's my Austrian colleagues who advise me that if I really want to blend into the culture. So I'm trying, probably not too successfully, which means I have to try again. So come here more often and try again. So I'm very happy to be here today to present to you a bit the DMA and what it was behind the scenes, what it is nowadays. Because as Thomas hinted at, I have been able, I have the luxury of being able to follow it since the very beginning, since the conception, the idea of what then became the Digital Markets Act, until now, where we have very recently just adopted the first enforcement acts and first conclusive decisions on the open cases and beyond. So really, it's the law in the making in a way. When I teach my course on digital regulation, and I'm colleague to your professor, as Thomas recalled, I have to change the program every year because things evolve so fast that the course that we taught this year is different from the course that we taught 3 years ago. And now this presentation today, so it's the latest of the situation that we have, but I tried my best to start from the very beginning. And the very beginning is like, why did we think of the DMA? What is the DMA for? And for all the talks that we heard recently, I like to stress it over and over again. The DMA is a regulation for innovation, because innovation cannot be only the one that is allowed by a few players who have a position in the market that allows them to be gatekeepers. Gatekeeper is the one that is standing next to the gate and decides what gets in and what doesn't get in. And that cannot be a recipe for unleashing innovation. So what the DMA wants to do is to give, to open another door. It doesn't mean to completely change or upset the organization of the garden that is behind the walls, but at least there is another access point where are people with different ideas that the gatekeeper may not like, because maybe they want to do it, or because they are doing it, or because their product is not as good, well, or because whatever other reason they might have, they should still be allowed to get in the garden and get access to the users, which is all of us that use these technologies, which we like, which we use every day, which we cannot do without, which makes those particular companies gatekeepers in themselves. So these are on the slide a couple of quotes from either articles. The first one here on the, I always have a problem, is it my right-hand side? I'm one of those with whom is right or the other right. So it's this right. So this is a quote from a paper on innovation that came out recently. But the other ones are actually quotes from users of the services of those gatekeepers who actually are starting to see the opportunities that are rising because the regulation is there. So say people haven't even been allowed to try. That's the recipe for innovation, is to be able to try. And if you have to wait for the authorization, whether it's the authorization from government, which companies complain about, or is authorization from gatekeepers, that kills initiative, kills ideas. And now people can try. The last one is my favorite, because it's not only because it says this can only exist because of regulation. So these are two young chaps from the United States. They even came, one of them came to our first workshop last year. We are doing that again, by the way, this year, and they will be live streamed if you're interested. We have workshops, one per gatekeeper, where they present their compliance with the Digital Markets Act. And in one of the workshops, there was this young chap with a cap with big Apple logo on it, so big fan of Apple, who said, like, I've been developing when I was in school this particular vintage game app, and basically Apple was not allowing it on iPhones. Now he has made, with his friend, he had transformed it into an app store, which now exists in Europe for vintage games, and of course also other apps. And this guy, who is a big fan of Apple, so it's not the usual suspects who might have some business interest against the company. This is a big fan who says, like, well, finally, thanks to regulation, they had to accept that we also have a chance, that we also get in. So, but that's not only about Apple. This is about Google. It's about Meta. It's about Amazon. And I will, in a minute, get to there and how we actually designated these companies as gatekeepers. So, how did we get to the DMA to begin with? Well, this is just a snapshot of what our life is nowadays, life of people and the economy itself. And you see, according to the statistics, gatekeepers now control more than 2/3 of the whole platform economy. Mind you, the platform economy, there are at least other 10,000 platforms active in Europe. We all think of the usual suspects, but there are many, many, many more. And these all contribute to growth, contribute to offer services, contribute to innovation, but they are small. And they are subject to all regulation that applies across the board to everyone. But then they struggle to arise, they struggle to have a role, and that's where the DMA comes in, that regulates only the biggest, only those with particular power and particular position in the market. But we know search engines and social networks, they control access to what we see. So, you know, this there is I think a quote from must have been from Cory Doctorow, who says, but it might be wrong, but the gist of the point is there is value in the services of search engine, social networks, app stores, because they organize information for us. Because there is so much information out there that we might feel lost, we don't know where to start. So a search engine that organizes the results, or a social network that organizes the content, or an app store, or a marketplace that organizes what you can actually find on the platform, is a service for you. And yet, what happens is that this service might become your only, again, access point to what is there. It's a bit as if people were telling you that, like, let me organize it for you. I know better what is good for you. Let me organize the content for you. I know how to do it. Let me organize all the apps that are there. The world is so dangerous out there. Let me do it for you. Which can be, again, a service that some people may like, but I keep saying that as a woman, this kind of paternalism always hits a nerve. So I like to have the opportunity to say, well, thank you. I also want to see the other side and decide for myself if I want it or not. Maybe I don't want anything else that is not out there, so that's fine. That is not organized by the gatekeeper. So that's the feeling that I get when now that's the personal touch when I enforce the DMA. That's the feeling that I get. Like I want to have a choice, and I may take it up or not. Somebody else may decide that they have different preferences, and that both of them are perfectly legitimate, but they should be possible. The political context that delivered the DMA was, so we are talking about, when we started, more than 5 years ago. It was, the report in the first bullet by the special advisors, this is probably from 2018, 2019, where the discussions about digital markets were ongoing. We also had an observatory in DigiConnect, so that was more the contribution on the DigiCompetition side. On the DigiConnect, so the digital side, we had set up an observatory for the online platform economy. Then, of course, all governments and parliaments were say, like, look, this thing cannot continue like that. If you haven't watched it, but I think it's a bit in French and a bit in English. There is even a documentary called EU versus Big Tech, that was broadcasted so far, I think, in France and Belgium. It's available online, and this shows a bit the beginning when in the Parliament there were the European Parliament, the first calls for we cannot let this giant dictate what we see and what we do, and all the way that led to the discussions in the Parliament and in the Council of Ministers of the EU to adopt the regulation. And the last point, this is not, and I think it's the next slide, it's not just a European problem. It's the same issue with the same companies that many jurisdictions are experiencing. And you see, there are an increasing number of cases in the United States. And I didn't put it in this slide, but I had also a slide with the list of the bills that were presented already in the past 5 years by Republicans, by Democrats to the Congress to regulate one or another aspect, all of them or many of them fitting the Digital Markets Act or the Digital Service Act, the sister regulation to the DMA. The Japanese, they have adopted a new legislation which is very close to part of the DMA. It's a bit smaller in scope, but still it's going in the same direction. The UK has adopted a different type of legislation. It's closer to competition law, in the sense of requiring an ex post investigation of certain problems. And others, Australia had elections, but they were on track just before the elections to also propose, after I don't know, like 3-4 years of market analysis, their legislation. India, but Indonesia, there are others I didn't even put in there. Brazil is super keen on regulation as well. So we are talking about problems that issues that everybody in the world is facing, and they are looking at the same. Everybody seems to be looking at the same issues, and you may have seen that a judge in the United States just ordered Apple to allow their customers, in this case it was Epic Games, the producer of the developer of Fortnite. I don't know if you are into games here. I always like to explain what this case, or it's not exactly the case, but what this issue is about is you are fighting a zombie. I don't know if there are zombies in Fortnite, I confess, but let's assume there are. You are fighting a zombie and you need a knife or you need a sword, and you will need to buy a sword, and you click, and in the previous situation you could only buy it via the Apple system, or the Google system is the same actually, and therefore paying a top-up for using the intermediation of the gatekeepers. The judge, the DMA, the Japanese law, they say this should be allowed now without necessarily going through the gatekeepers. So disintermediate this, which is a transaction after all between me and not the zombie, but the guy that is selling me the sword. So I should be allowed to click, buy the sword at the price that Fortnite is, that Epic is charging me, without the need to pay the extra for intermediation, which is unnecessary because I'm already in the app by Fortnite. So that's a bit the logic, and it's the same again across jurisdictions. Just an example, but there are many of them. All the issues with the search engines, all the issues with the self-preferencing of results in when you do a search online. What is so special about digital markets? It's their own characteristics that over the years they prove to be creating a situation that is quite different from other markets that we've been monitoring via competition law for many years. We don't need to regulate markets if the dynamics, they sort themselves out, or if there is a problem and we can intervene after the problem is materialized. Well, here, these markets are very peculiar because you have extreme returns to scale. So it's, in a way, it's like adding together with the strong network effects that you have. So if we are all on one social network, there is no chance for somebody else to come and launch another social network, because everybody would need to migrate at the same time. So who's gonna do the first move to get there? And data. Once these companies in particular have been able to collect enormous amount of data from us, from all the users, that creates an advantage that nobody else can match outside and challenge them. So that creates a strong momentum for this market to tip at some point and impede that from now on you can have a regular competitive dynamic that would restore the well-functioning of the market mechanism. So we need to do something to allow this market mechanism to function again. So when we say the DMA is pursuing the goals of fairness and contestability, which is not competition. Contestability means, okay, there is a market that is controlled by one or more gatekeepers, but we want that others have a chance to get into that market. That's contestability, it's openness. It's the chance to challenge who's in the market. It's not about now appointing someone to be a competitor, but it's just to allow whoever has the right idea or the bright idea to actually compete. So these were I anticipate most of what is in the slide, so that's good because I have too many slides and I can go fast on this one. So these were basically the problems and the objectives that the DMA wanted to address. So that's also just one point that is very important. The DMA takes a lot of inspiration from competition law and competition practice, but also from the regulation of platform to business relations. So that's the fair business relationship between platforms and their business clients, and other experience that we had, even inspiration from access regulation from the telecoms world. And in this regard, it's important for you students and practitioners and experts of European law to remember that this is an harmonization regulation, which means it's based on the legal basis of Article 114, harmonizing across the internal market to eliminate barriers in the internal market. So why am I now specifying this? It's just to make clear that it's not a competition instrument. And that will be very important also to understand why the enforcement has been centralized, why we have not only an issue of how do we coordinate with possible competition cases that might be looking at the same situations, but that also other regulatory frameworks might be involved in this case. You may have data protection frameworks, you may have consumer protection frameworks. So it's a broader regulatory framework that now adds on the digital markets for the purpose of fairness and contestability. So that's the keywords that we keep using. So who are the gatekeepers? I mean, I anticipated a few of them. This is the official picture on the website of the DMA. So we managed to have our own website. It's not very digital -market -act .europa.eu. Whatever, you know, it's not very easy, but you Google it, you search it through a search engine and you'll be able to find it very easily. So you see that we have 7 gatekeepers now. The latest addition is booking.com. Who was not a gatekeeper until maybe less than a year ago, because, and I will tell you why in a minute when we discuss why they are gatekeepers. What is also interesting on this slide is the services for which these companies are regulated. So this is also an important feature of the DMA. It's not that we are supervising the company as such. We are supervising the company for certain specific services that are covered by the legislation. So you see that, for example, in the context of social networks, we are monitoring. ByteDance is the parent company that is offering TikTok. So TikTok is one of the social networks that we monitor that belongs to ByteDance as a gatekeeper. Facebook and Instagram are both owned by Meta as a company, so Meta is the gatekeeper, and we monitor these 2 services. But we also monitor Meta Marketplace, and I need to update this slide. I didn't notice, because Meta Marketplace has just been, I don't know if it's a designated or undesignated, but basically we just revoked the designation of Meta Marketplace, because it doesn't have anymore the characteristics of gatekeeper. So that's just as an example. And also, if you see in the concept of the category of intermediation, there are many. So if you are familiar with competition law, you would know that generally if you have a dominant position, a company in a dominant position, you have 1 dominant position, maybe 2. If you start having more companies, then it starts already being a complication to argue that it's perhaps collective dominance. Difficult to say that you have 3 or 4 or 5 and they all are dominant. And that's one of the differences the DMA introduces. This is not about being dominant. This is about being a gatekeeper, and there is no single market, There is a single market. There is no specific relevant market we are looking at, but it's a category of intermediation. And in this intermediation, you can find things that are as different as Google Maps, Google Shopping, the App Store, Google Play, that's another app store. So these are all intermediation services. And yet all of them are gatekeeper according to the requirements of the legislation. So how did we identify these companies and these services? So the logic is, to make it simple, you are big, you are important, and you've been there for a while. That's the summary of what the gatekeepers are. What does it mean you are big? Is because you have a substantial significant impact on the internal market. So there is a very high market capitalization. So the market value of this company is extremely high, 75 billion. That's a huge amount. Or you have a revenues in Europe of 7.5 billion. So how did we pick these numbers? They are not just picked randomly. We looked at the average market capitalization of the biggest European company. So we took Eurostoxx 50, and we saw what was the average market cap in the year when we were drafting the legislation, and this was the average cap. So if you are so big as to qualify to be big in Europe, then we look into what you're doing. So there is a logic behind it, not just like, oh, let's fix the threshold so that we can capture only some companies. That's not the way we went about it. So that's the first criterion. And of course, you are across member states. You are important. So you are an important intermediary between us and users, and maybe some of you are as well, developers, business users, others that use those intermediaries to reach us. If you are a developer that want to reach the users of an iPhone or of an Android phone, they have to go through respectively Apple and Google. There's no way to reach me with an app unless they accept the terms and conditions of Apple and Google. That's as simple as it is. Amazon is a huge retailer, not only retailer and intermediary, and actually that allows me to say that they are regulated as an intermediary. They are not regulated as a retailer, because as a retailer they sell their own goods. So that's not our business. Our business is when a smaller Maltese company is selling via Amazon, and the only way to reach to reap the benefits of the internal market across the 27 member states is to accept the terms and conditions of Amazon. So these are the type of issues we're talking about. So the thresholds were set in that case with 45 million end users, which is 10% of the European population, basically. That's the choice of the criterion. And the 10,000 yearly business users. Now, the 10,000 is just a number to signal that it's quite significant. So for that, I don't remember the benchmark, if we had one, but it's a bit the size of the platform economy, as I recalled before. And this has been going on for at least 3 years. So that's the entrenchment of the gatekeepers. So these are the quantitative thresholds that the legislator put in place. Say, like, if you fulfill this, then it's extremely likely that you are a gatekeeper. Now, because it cannot be that you fulfill a threshold and then forever you are qualified as such, this is not an absolute presumption, it's a rebuttable presumption. And we had several cases of request of reconsidering, like, yeah, okay, I meet the thresholds, but actually I'm not a gatekeeper. We had 3 investigations into Microsoft services, Microsoft Bing, Microsoft Edge, Microsoft advertising. This advertising these services are not designated as gatekeepers because despite fulfilling the thresholds, they were not a significant gateway, an important gateway. At the same, we had, I think that caused a bit of a stir a year ago. X fulfilled the threshold. So X, formerly known as Twitter, used to be a small company with, thriving on advertising. But revenues were fairly small, market cap was fairly small. So even when when I think at the time of drafting the DMA, they were very far from the thresholds. They were not the big companies that would qualify for the average capitalization in stocks, Euro stocks. And then what happened? Twitter was purchased by someone controlling many other or bigger companies, and according to European law, it's the controlling shareholding that matters when you calculate the market capitalization. So all of a sudden, even though things had not changed, X had the market cap that would fulfill the requirements of the legislation. So we had to look into that. So we were in touch, we discussed, we even opened an investigation to look into whether it was correct that despite meeting these thresholds, X was not a gatekeeper, and we concluded that X is not a gatekeeper. So X is not designated as a social network under the DMA. It is subject to regulation under the DSA, but this is it's my colleagues and the other 3 corridors on our floor that are in charge of it. So on our side, we did investigations and we closed it in 5 months. That's the duration to establish the rebuttal. So that's a few examples of why even meeting the threshold is not the end of the story. Then there is the reverse. You don't meet the threshold, but things point in the direction that you may be a gatekeeper anyway. And that's the vertical line on the slide, the qualitative criteria. We can still do an analysis. The Commission could launch a market investigation, look into this, and see whether, despite maybe the market cap is not as high or the number of users is below the threshold, but nevertheless, the company qualifies as a gatekeeper and the service qualifies as an important gateway. And we did that also with iPadOS. So one of the services that is regulated under the DMA is the operating system of the phone, the operating system of the computer. So we have designated iOS. In practical terms, you can say we regulate the iPhone, but in reality, we regulate the OS. The operating system. We cover Android. You see the list is here, but we cover Windows PC, but we also cover iPadOS. And iPadOS has numbers that are below the 45 million users in Europe. There are not 45 million Europeans who have bought an iPad yet, at least at the time. So we opened the market investigation because we thought we still see that because of a number of, besides the growth path, which they were coming extremely close, I think they were around the 40, if I'm not mistaken, or around that, so of the 45 million. Plus the network effects, the ecosystem effects that were in place, they could still qualify as iPadOS could still qualify as a gateway. And we concluded that it was the case. We did that market investigation very fast, in fact. It was, we have 1 year in the legislation. We finished it in a few months before. I think we could have done it in 6-7 months, then it became 8 months, but there is a lot of procedure also behind decisions. So we have already experimented with a few of those things. These are just the list of services that are covered by the legislation. So if one of those companies, or maybe future companies that fulfill the quantitative criteria or qualitative, offering one of those services, they can be designated. So it's why is that important? Is because if the service is not listed there, we don't look at that. So when nowadays people start asking, what about artificial intelligence? Well, either AI fits into one of those, or this is beyond the remit of the DMA. Okay, so that's and there may be other things that that fit. And maybe one thing, we regulate online advertising. You see it in the middle. But this is a very peculiar situation because we cover online advertising only insofar as it is offered together with another core platform service. So it's not the regulation of advertising as a whole, because that's a huge service market and ecosystem, but we regulate it all insofar as basically the gatekeeper is also offering maybe a social network, a marketplace, or a search engine, which is the current case for the currently designated ads that you can see there. So Google, Amazon, and Meta, because they offer also other services. So we don't designate whatever that is, the biggest advertising agency in Europe that might fulfill the thresholds, but they don't offer any other service of the type. Okay. So what happens to gatekeepers? Where am I? Because I tend to speak too much. How much time do I still have left? Okay. So just to talk a bit about the obligations. So what's the consequence of being a gatekeeper? It's not the end of the world. It's just that there are a number of obligations that try to implement, remember, fairness and contestability. So fairness in business relationships and contestability, opening of markets. So it's not, the DMA is not meant to be an open-ended form of supervision where we can find whatever is going on and discuss it. We have to monitor the respect of very specific obligations. Some are negative obligations in the sense of thou shalt not do this or that, so prohibitions. Some are positive obligations, so impose certain specific behaviors. The other important thing is that these are directly applicable obligations. So we were just briefly discussing it before. That means if you are a business user, this creates, well, again, you are students of European law, this is a regulation, is directly applicable, it creates rights and obligations directly on businesses and citizens in Europe. So you have your rights, so to, if the DMA grants, or actually obliges, for example, Meta, taking this because it's a case that we have run, to ask for consent to combine the personal data of its users across the services that they offer. As a user, you have the right to require Meta to ask you for your consent. So what is an obligation on one side means it's a right on the other side. So that's also a very powerful impact of the legislation, which is probably more than for us individuals, which it is important, but is very important for the businesses whose opportunities now have to be granted, business opportunities, innovation opportunities have to be granted by the gatekeepers. And if they don't, they have recourse right away to us, the Commission as a public enforcement, and to courts as private enforcement. Now, there is a difference in the obligations included in the DMA. The next slide is a mapping of the obligations. So this is just the framework. Some of them were considered as directly implementable. You have to ask for consent, period. There is not much to discuss. There was, I can tell you, we had the case, so it lasted 1 year, so there was something to discuss visibly. The other list of obligations, they can be implemented in different ways. So what the way they are considered in the legislation is they are eligible to be further specified. So you can comply, for example, and that's also a case we have already run. It's not a case of proceedings. There is an obligation for operating system operators to offer interoperability free of charge. Interoperability means that if I have a Ray-Ban VR glasses, for example, or a Garmin watch for running, this should work seamlessly with my iPhone. That's what it means in very concrete terms. This has to be granted free of charge, but there are different ways to do this, especially when the iPhone was not designed as like by design giving access, but it was always subject to Apple decisions. That was the state of the iOS until the DMA. So how do you move from the previous situation to the new one where interoperability has to be granted? So we had long discussions. We opened the specification proceedings and we gave 150 pages. I think this is still in not yet being published, but it will, the decision. So explaining to Apple how to do the interoperability, how to offer interoperability to those requesting it in the way they are described, whether it's goggles, it could be your Bose earphones, for example, or whatever other physical device that you want to use. But it could be also something that is not a physical device, because interoperability could also be with a new app that provides AI-based summaries, but they don't want to use the one that is offered by Apple or Google. Again, you're taking Apple because we did the specification, and want to use their own system. They have the opportunity to connect directly to iOS. They don't have to go necessarily through Apple. That's so it's not only the physical devices, but also the apps or other services that might be offered. So now the original compliance was supposed to be ensured within the first 6 months after the legislation came into force. Things are never so straightforward. It took a long time for the telecoms market to be opened up after telecoms regulation was introduced. So we are working with the companies to achieve this result. So this is a mapping of all the obligations. It's tough to go through all of them. They are like 20 or more. If you count the reporting obligations, is even more than 20. But some of those I mentioned already, like obligation to request consent for data combination, the obligation to grant interoperability that I just described, but there are other things. The obligation to allow an installation of the apps or choice of the default. For the first time, I could choose on my iPhone. By the way, I have an iPhone and an Android phone, so I like all of them to have my data. I like to see also how they differentiate the systems. I have also my preferred one, which I'm not now going to go into, but for the first time, I could decide not to use Safari as a browser, but I could tell my iPhone to use DuckDuckGo browser. I didn't even know that DuckDuckGo was a browser as well. I knew it as a search engine. So now I'm also experimenting this one. And users are now entitled to uninstall everything that they don't like to have. If I mean, in principle, theoretically, I could uninstall the App Store of Apple and only live with another App Store. That's totally feasible under the DMA. Of course, there is no App Store that can allow yet all the choices that are in the Apple one. I can decide not to have an App Store, because the DMA also obliges to offer direct distribution channels. So I can go on the website of Spotify and download on my phone, whether it's an Android or a Google phone, directly the Spotify app from the web. the DMA also authorizes that. So I can decide I don't want an app store. I just want to shop around wherever I find things. So these are just examples. It's work in progress. It's not yet like that. There are some alternative app stores on both Android and iOS, but we are not yet in the nirvana situation that the DMA had prescribed. And then transparency obligations are there, data portability. There are obligations of real-time data portability. So a business user, but also an end user, could just take their data real-time and have them, and perhaps move them to another service or use them to develop a different service, a competing one. That's the innovation idea behind. And many more I'm not going to dwell into, and I have a couple of slides on, I forgot that one. There is also, this was very much pushed in the European Parliament, an obligation to offer interoperability of messaging apps. Now, the two messaging apps that are regulated, that they are subject to these obligations, are actually both from Meta. This is WhatsApp and Messenger, Facebook Messenger. So at this point in time, there is a reference offer. So WhatsApp and Messenger have put out, like the telcos, they have put out an offer saying, like, if you want to interoperate with me, these are the specs, these are the contractual conditions, you can request interoperability. Has anybody requested interoperability? Not yet. We are following that up. Data combination, the mobile ecosystem I discussed. Last word is about enforcement. So the DMA is a regulatory instrument. That means most of what we are discussing happens behind the scenes. Meaning it doesn't result into big headlines. The Commission has opened another case and a case and another case and another case. We may open cases, but most of it is what we call the regulatory dialogue with the company. So we meet, we discuss, they say, this is what we did, we react, we say, we don't think this is accurate, or we don't understand why you're doing it this way, you have to give us more information. And over time, things change. And they've changed in the past 2 years of discussions with the gatekeepers. Because what the DMA is about is not to look for wrongdoings, is about ensuring ex ante, as we say, that there is compliance. So that, in fact, in the ideal world, you don't even notice that there is a problem because we have corrected it before it emerged. Now, the real world and the actual world are usually very different. So there is a lot of work to do. And that's why if you go through the notification, designation, compliance report, regulatory dialogue, then non-compliance actually happened. And here you have the examples of non-compliance cases. And you can go as far as having cases of systemic, well, actually systematic non-compliance. Sorry for the mistake. Systematic, because if you have 3 instances of non-compliance, then the penalties can go up very high, so up to 20% of the global turnover. That's huge. Global turnover of Apple is 350 billions. Turnover of Meta, these are the 2 companies that we have found recently, is 160 billions. 20% is the GDP of some country, you know. It still requires some quite some wrongdoings to get there. So it's not an immediate route. You have seen perhaps the fines that we started now levying on the companies. They are actually completely very, very far from those numbers. This is not something that we take very lightly. And there is another consequence of systematic non-compliance is actually the possibility of imposing remedies that can go as far as asking for structural separation. Like the US has requested, the DOJ has requested Google to spin off Chrome, so that Chrome should be independent from Google as such. alphabet, I should say. So potentially, theoretically, we could go as far as requiring this type of remedies. So that's in a nutshell how the DMA works. And we have a very detailed toolbox that we can use. We can do multilateral, but that's also very important for me to underline. I always so far refer to discussions with the company supervised. We have a lot of discussions with the rest of the market as well, and with civil society for completeness. So we don't want to have a one-to-one conversation as enforcers. We want to have a multilateral conversation. Some of them can be public, some of them cannot, because there are confidentiality issues, business secrets, both vis-à-vis the gatekeeper and the third parties. But once again, that's also why we are organizing these public workshops once a year. So the next ones will be between June and July. I think they should have been announced officially today by the colleagues on the website, www, digital markets, etc., so that they are taking place in the next few months. This is also to foster a broader conversation, because also one of the problems with digital markets is the huge asymmetry of information between the regulator and the regulated companies. How are we going to fill this gap between what we know and what the companies know? So one of the ways, again, is to make it a public conversation. It doesn't solve all the problems, but it helps generating knowledge. And the technical meetings that we had, for example, in interoperability proceedings, these were followed by the publication of the measures that the Commission was planning to impose for specification, so that there could be input from third parties. We also got input from citizens, say like, oh, we like it, or well, we don't like it. These are less relevant for this particular work, but it's also good to know what the views are in this respect. So there is a quite rich supervisory toolbox. So for those of you who are experts of competition law, it's also quite different from, some of them are similar as tools, but there are things that are specific, DMA specific, I would say, and also much more public under the DMA than under competition law, precisely because under competition you are investigating a potential wrongdoing. By default, you are investigating a potential wrongdoing. That's how it works. So you need to keep some more confidentiality of this, because the wrongdoing may not exist. In this case, we're saying if I am monitoring self-preferencing, I can be very open. I'm monitoring Google, Amazon, Apple, etc., possible self-preferencing, that this actually is not taking place. I'm not assuming that there is a problem. I'm assuming that there is no problem, but I'm monitoring. That's the nature of regulation compared to export competition enforcement. And this is the last, so I promise now, the last slide. There is one, it's just a summary. What have we been doing in terms of when we needed to go beyond the regulatory dialogue, so that the discussions with the gatekeepers were not delivering what the law was asking. This is not to say that in all other areas we have achieved what the law wanted, but that the dialogue is still ongoing. But these cases, they seem to us as quite obvious cases in which we needed to take a formal position, and probably we'll also have now the court position if the companies decide to appeal, which they have 2 months to do, and these 2 months end in July. So we have opened already in March last year 5 cases right away. We had a case for steering. That's the sword and the zombie example, because both, in our view, Apple and Google were not complying with giving the freedom to do this direct purchases between the app developer and the client. For Apple, we adopted a decision 2 weeks ago. For Google, we are at the stage of the preliminary findings. So the process is that you open an investigation, you investigate, you speak to the company, you speak to the customers if necessary, and when you have formed your views as the supervising authority, you have to send preliminary findings of non-compliance, if that's what you find, to the company. And that's what we did with Google. With Apple, we had done it already in June last year. So we opened the case in March. In June, end of June last year, we communicated to Apple that we thought they were non-compliant. For Google, it took a bit longer for a number of differences in the two cases. But we also communicated to Google, we think you're non-compliant for this, and this reason. And the preliminary findings paper should also tell the gatekeeper the principles of what they should do to comply more in detail. So not only like, well, go back to the law and read the law. We also tell them you are non-compliant for this reason, so you should adjust in this direction. That's what the preliminary findings of non-compliance do. Then the company has some time afterwards, right of defense, access to file, they send feedback, they may make proposals to change their approach. That may or may not work. So I have a palette of examples. So there was a case in which what the company proposed worked. So we had a case against Apple for a choice screen. Apple had to give the choice of browsers, the DuckDuckGo example I gave you. There we didn't even get to send them our preliminary findings of non-compliance, because the company proposed a number of changes which are now being implemented, which seems to broadly satisfy the requirements of the law, so we closed the case. So there is no preliminary findings, no fines, no discussion anymore, but continuous supervision, because this is not something that is finished. It will continue. On the steering, the zombie example, Apple proposed, they received our preliminary findings in June. They discussed, they made some proposals, the proposals were discussed, but ultimately nothing happened. We issued a final decision where we confirm that we think they are non-compliant. Now Apple has 2 months, 60 days to propose a compliance measure to now put things right, basically. That's the process, and we will continue the discussions with them. We had the same, so for Alphabet, so for Google, we are still at the phase where they have exercise the right to access to our file, and they will reply to our preliminary findings, and we will conclude the case when this analysis is finished. The second case, which we concluded 2 weeks ago, is a case against Meta. Now, I presume that most of us have used one or the other service of Meta. In particular, I'm thinking about Instagram and Facebook. At some point, you will have noticed, if you use these services, that you received a message saying, look, the law has changed. Now I have to offer you two possibilities. Either you give me consent to fully personalize your feeds and your ads, or you have to pay €9, whatever it was at the time. So that was November 2023. So in March 2024, I said, like, look, no, this is not the way to. Well, we had told them also before, but in March 2024 is when the DMA came into effect for them. We said, no, this is not complying with the requirements of the DMA, and we opened the case. We communicated to them in July last year that the reasons why we didn't think the consent of pay was in line with the DMA. they replied, we had follow-up discussions. Then in November, they they decided to roll out a new model where actually they do give to users a choice to receive less personalized ads, so to still accept ads, but in a way that are less personalized. So that changed the situation a bit. So we still now have adopted a decision where we conclude that consent or pay is not what the DMA requires. At the same time, now it's not anymore about consent or pay, it's something else. So we still told them, you have 60 days to comply fully with the order, but you have something else on the table. So they have to come now, and we'll discuss not only in the 60 days, but even beyond, for the constant monitoring I keep referring to. So how to make this system fully in line with the DMA. So they also got a fine like Apple, but Apple for the steering they received a fine of 500 million, and Meta of 200 million, but also their infringement was shorter, because in November, at least the first part, the pure consent or pay was not there anymore. So that particular type of infringement was over, and now we have to see what happens with the new model. So we have different cases that and different ways of looking at the cases. And as I promised, I'll stop here. But just to say that the evolution and all the things that happened this year, it's 1 year that we are 1 year and a few months that we are implementing the DMA plus the designation phase, have been extremely rich, extremely demanding, extremely interesting. And if I come here next year, I'm sure that I will tell you even more new things that will happen in the next year. But for now, that's a bit where we are. This is the new normal that we hope to see very soon, thanks to the DMA. And with that, I just thank you for your attention.
Thank you. I'm looking for. Thanks a lot, dear Filomena, for the rich, dense, very informative, very enjoyable presentation, and I'd love to have you back here next year for another one. I have a number of questions, but I would rather give the floor to the audience for their questions, remarks, observations. Yes, please.
Adnan Tokic, University of Vienna. Thank you very much for your lecture. You said before that contestability is not competition, but however you put on your first slides the keywords antitrust, and without going into the discussion whether the DMA is antitrust law or not, maybe to get another perspective from you, does your DG work together with the DG Comp when it comes to the DMA, or is it just your work? How is your insight with respect to that?
Okay, I will. No, the first thing is that the DMA is not antitrust. That's it's just a fact. Also, the legal basis is different, the methodology is different. So the fact that we took inspiration from antitrust experience is a fact as well, but that doesn't make the regulation an antitrust instrument. Telecom regulation is not an antitrust instrument, and also took inspiration from the experience that we had before. So the DMA is a joint venture of DG Connect and DG Competition. So we work together, and this is quite an experiment in the administration, because actually we have a team that is basically two teams, but actually they work together as a joint team. So whenever I describe the cases, for example, I was following directly the meta case with a colleague from DG Competition, who's also team leader, so head of unit in DG Competition, and we have a team that is composed of members of the two DGs. So the idea behind this construction is that it's good to have people with the experience of competition enforcement, but it's also good to have people with the experience of tech. And that's the team that that we are building now. We don't even make difference anymore, because I call all of them, the colleagues, DMA native, because it's true we still have some people who have done one or the other track before, but many of them, they were just recruited in the past 2-3 years. So actually they are all DMA native. So it's a nice constellation, very different from the usual vertical hierarchical structure, because it's much more. We like to consider ourselves a bit as a startup of the administration, because it's not obvious how to make things work, but it opens up opportunities to actually create new ways of working that might suit us better. I hope that satisfies your curiosity.
Maybe I can follow up with one question before we take further questions also on that aspect. The DMA, indeed, I mean, it reminds us of competition law and from the competencies, what the Commission does, from the closeness of what is regulated to antitrust and so forth. So I have a general question. Could you remind us of the reasons why it was based on Article 114? But that's just a nod on the antitrust chapter. And secondly, more on substance, I have a feeling that maybe if the DMA had been embedded in the antitrust context more closely, excuse me, perhaps the blanks that it leaves or that now need to be filled through practice in terms of procedure, but also the scope of the obligations, the proportionality of sanctions, or also national court competences, the rights of individuals before the national courts. Maybe antitrust could have more closely inspired and filled those blanks, inspired the application of the DMA. So that's my second question. Do you think that would have helped? First question, legal basis. Second question, would the antitrust context have helped? And the third question, still more detailed in that regard, is on less efficient competitors, or the as efficient competitor test. My understanding is that the DMA protects less efficient competitors also. It protects everyone to keep the markets open. But I wonder, does the AEC or this efficiency thinking at all play a role in the application of the DMA? So in terms of, for example, the obligations that need to be specified, the scope of the obligations, or the imposition of a remedy. So what the effects on what type of competition, what type of market those effects were present. So I only harmed the less efficient competitors, and therefore I get a lesser fine. Is that in any way a line of thinking under the DMA? Sorry for wrapping 3 questions into
Okay, I took note. I hope I don't forget.
I'll remind you.
Thank you. I count on that. So why did we chose the harmonization? Because the DMA is not, it's not created as a, I described it as an ex-ante form of regulation. So the DMA does not intervene to investigate wrongdoings, which would be the basis of an ex-post competition type enforcement. But what it's doing is harmonizing the obligations that are applicable to certain legal subjects, so to the gatekeepers. So this is the logic of an harmonization regulation. And they have to be harmonized across the internal market, otherwise you create obstacles for if you have German obligations different from the Italian one and the Polish ones. So that was the logic that that fed the choice of the legal basis. but also the fact that indeed the logic is not of, there are investigations, but the investigations are only meant to pursue compliance, are not meant to find out whether there have been violation of the very general principles of in the past. So there is a different logic, and there is the harmonization logic across the internal market. There were a number of countries that started introducing legislations to capture this effect, and that if too many differences would be in those legislations. We had something in Greece, something in Germany. We had, when we started originally, I think even Britain was still in the very early discussions, one of those. So to avoid that would lead to fragmentation, was chosen, the legal basis was chosen of actually harmonizing. But that's also why it's the DMA, and I'm using this word, is about harmonized obligations. So what these companies will have to do. And then the rest is functional and is pursuing the objective of ensuring that these obligations that are harmonized are respected. So it's reversing the logic of investigating to figure out whether the law, the general principle in the law has been infringed. I don't know if that makes sense to European law professors and students. The second question was, could antitrust help? Antitrust does help. The thing is that given that the logic of it is different, you have to think how to import those principles. You say that we have a framework for rights of defense, for enforcement at European level, indeed, and part of it fed into the DMA structure. It's even reported in the procedural part of the DMA, or inspired the procedural part of the DMA. Just for to enlarge the scope, the sister regulation, the DSA, has very similar procedural rules, because also in the DSA we took inspiration from the procedures that were in place under competition law. So that's totally the nature of things, whether or not the DMA, or even less the DSA, are competition law instrument. The DSA certainly not. But the logic is you have a very an example that is established for a long time of centralized enforcement at European level that you can use to inform other forms that are emerging now of centralized enforcement in terms of procedures, in terms of defense rights, and the like. On the other hand, there are many more regulatory frameworks that we can look at, because you have financial supervision that is also centralized, is based on, it doesn't come from competition principles, or not all of them. There are perhaps some elements, but this is prudential regulation mostly. So we can also take inspiration from there, because there is practice there. And we can take inspiration from the telco regulation, the energy regulation, because there are elements of those that can feed into, take for example, how do you calculate the fines in non-compliance or an infringement case. Competition law has a long experience, has guidelines and so on. In other areas, there are no guidelines, and the DMA has no guidelines yet. So what do? So you try to fit, to find the best way to fit the new situation. And that's what we did. When we finally published the decisions, after we cleared the confidentiality, you will also see the type of reasoning that we used. So actually, I would say that the answer to your question is that you don't need it to be embedded in competition, legally speaking, or as a legal basis to take inspiration. Mutatis mutandis, but you can also actually, that gives you the freedom to take inspiration from other forms of regulation that can feed your reflections.
Good question, efficiency and...
Efficiencies. Now,
but also as efficient competitors, so the impact on the market, who was impacted?
Look, I think the DMA, for me, but I think it was even used before as a metaphor, it's like the traffic rules. So it's not about I have a good reason for speeding on the highway. You may have a good reason, the speed limit is still there. It's more efficient that I get to the hospital earlier or to the school earlier. The overarching goal of the regulation in this in the traffic regulation is safety. Says that this is more important than achieving more efficiencies. And that is the logic we should look at this question. So it's not, of course, there were a lot of analysis, economic analysis of the different behaviors that now have been regulated under the DMA. And it was concluded already at the time that the efficiency was not the possible theoretical case-specific efficiencies were not as important to justify leaving it to an ex-post analysis, basically, because that would be the alternative. So the rule is there. It has to be respected, but also I don't believe that it's the less efficient competitor, because this is just leaving it, creating new opportunities. For example, the data advantages. If I am a smaller competitor, I don't have the data that the gatekeeper has. So I'm less efficient if that's your benchmark, having a lot of data, but should that be the benchmark even for efficiency? And efficiency of what? So I think now I'm getting a bit philosophical in this, but that's a bit the logic of...
but also not for the fines of proportionality. It doesn't... The fact that I harm the market that probably couldn't perform up to my standard will also not diminish or lower the fines, no.
The fines is, I mean, once again, the fine for breaching the speed limits will depend on how much you did the breach. So that, how we are looking at it.
Thank you. We have a question online.
Yes, we do have a question online from Markus Frischhut from Innsbruck. First of all, thank you very much for this great insight. One question. As you have mentioned other countries, example Brazil, do you expect a Brussels effect for the DMA, maybe also for the DSA, as we saw it in case for the GDPR, keeping in mind that for another document?
Keeping in mind, sorry, I didn't catch it.
The last part was keeping in mind that for another document. Literature is more skeptical.
Okay. Look, I didn't talk about Brussels effect. I'm just saying that all the jurisdictions I mentioned, but even beyond, we are all grappling with the same issues. Now, every jurisdiction is, the Brussels point is just that we got there first, basically, because now Japan is there, the UK is there, Australia might come there, but it's just a proof that there are issues in the digital markets that we need to correct, and everybody is looking at them in roughly the same way. It's not exactly the same because every jurisdiction has peculiarities. So if at the end the US wants to go the antitrust route, but the remedies are very similar to what we are imposing as obligations in the law, it's not that we say like regulation is better than antitrust, if at the end we are aligning with what we want to see in the market. And the same for the other jurisdictions. So I think now the most important, the most interesting point will be how the different jurisdictions will align what we call obligations, others call remedies. In the UK, they call them conduct requirements. So how do they align all together to make sure that also for the companies themselves, this is not just a manageable patchwork of different things. So will they be exactly the same as what we proposed or with what we enacted? I'm pretty sure they will not, but let's see where we land in a few years of enforcement.
We're nearing the end. Last round of questions, Professor Lehmann. Microphone is coming, hang on.
Thank you very much for a very insightful presentation, and I agree that many of the things that you did are very useful, especially for users. But from what I understood is it's mostly the ambition is mostly to create an internal market that is able to compete with the US. And you probably know that we have a huge gap, especially in the services that you're talking about, to the United States. Most of the cases that you're doing deal with US companies, and not by coincidence, we basically don't have them in Europe. Now you say you create opportunities with this regulation, and perhaps it's too early to assess whether this will work, but can you think in terms of competitiveness, also of alternatives? I mean, do you think it suffices to create through regulation these opportunities for smaller companies, or do we not need also other measures to have a European Silicon Valley to replicate the success? What other measures do you think we also need?
No, it's a very important point you're raising. I would start by saying, like, the objective of the DMA is not to create a Silicon Valley in Europe. The objective of the DMA is to correct the most egregious, eliminate the most egregious obstacles for, as I said, opportunities, and giving the choice of the next bright idea within the existing ecosystems, and possibly even beyond the existing ecosystems. Now, the DMA does not, by design, tell where we want to land, because we still believe that this should be in the freedom of conducting business of the gatekeeper and of the others. And that's what we were focusing with the DMA. Like, it's not only the big ones that have freedom to conduct business, also the other ones. So how do we reestablish a good relationship of this? Now, will this make Europe more innovative? We think yes. This will make even the US more innovative, because these opportunities are not limited to to European companies. These are open to everyone who offers services in Europe. So there's no extraterritoriality of effect. At the same time, if it's a Japanese company offering services in Europe, they also benefit of, they're also business users under the DMA, basically. Now, do we need more? Of course we need more. The Commission, and that's where the head of DG Connect comes in. There is in the making a Cloud and AI Deployment Act, which is expected to follow in the lead of the CHIPS Act to develop more technological capabilities in Europe. There have been also other initiatives to stimulate investments directly into more innovative ideas. So this is another aspect of the problem that I don't believe you can correct it with regulation. Regulation is to clean the space so that things can emerge, but for the rest, that goes, I mean, there was a moment where industrial policy was a negative buzzword for those believing in the market mechanism. I think we've moved on from there, and we see that industrial policy can complement and stimulate the market mechanism to go in a certain direction, which is conducive to more innovation, because despite everything, that's the mantra we are hearing all the time from all European politicians: innovation, innovation, innovation. So I hope that the combination of different things will achieve that. And let me just say something, because I keep hearing, yes, Silicon Valley, yes, tech, AI is the new battlefield, but at the same time, during COVID, 3 out of 4 of the most innovative vaccines were developed in Europe. So Europe is behind in innovation. Let's qualify the statement as well. So just a little personal comment on the point.
All right, thank you very much. With that, we have exhausted our time frame. Professor Chirico, dear Filomena, thank you very, very much for being here, for sharing your thoughts with us. Thank you all for coming and joining online, offline. If there is any of the buffet left, please go and finish it. And thank you again to the sponsors, to the team. Our next EU law workshop is in fall. The dates are on our website. Hope to see you there. Goodbye.
Thanks, sir.
Great presentation.
I'm sorry, it was